And pardon me for 1 minute. Somebody's knocking at the door. I'll be right back. Sorry about that. Judge, there's actually somebody from the CCA asking about, from Judge Hervey's chambers, asking a question about related to the LAR.
Oh.
I'll get back to him. And I've not heard back from Chair Collier. Let me just double check. So, Mr. Bunnan, as chair, I defer to you and when you want to start.
Okay. Well, at least we can get through getting the minutes approved, I guess. Megan, you want to call roll?
Absolutely. Mr. Alex Bunnan,
Here.
the Honorable Sharon Keller,
Here.
Representative Nicole Coyer. Mr. Bunnan, we have quorum.
All right. Then the minutes from May 20th appear in the meeting book. Their motion for them to be approved, Judge?
I move for them to be approved.
Okay. And unless there's any discussion, all in favor? Aye. And they're passed unanimously by the quorum. I have no opening remarks. Do you have any to kill time, Judge?
You know, I don't, but I think we could probably get through the Maverick and Zavala counties without Chair Collier missing anything too much, don't you?
That sounds fine.
Okay.
So that's Joel. Can you brief us on that?
Yes, if you could please turn in your meeting notebooks to page 4 for an update on the Maverick and Zavala County monitoring that we've done. We've had a long history of monitoring in these counties going back to 2008. Our latest report was issued in April of 2022 for both counties. Maverick County has not yet responded to the report. They requested a 60-day extension and their due date is in about 2 weeks. All of the issues in their report relate to the accessibility of appointed counsel. And the findings for this report are on page 5. For Zavala County, they responded to the report. Their findings are on page 6 and their response is on page 7. I believe that their response addressed all of the report's findings and recommendations, and all of the findings had to do with accessibility of appointed counsel. One of the things that Zavala County listed in their response was that magistrates would report to the commissioner's court on a monthly basis with regular statistics. I believe this is a very good plan. And we would like to go forward with a little more than what they proposed. We'd like to have some supplemental data reporting to us. In past reviews for both Dallas and Hidalgo County, we've required counties to give us supplemental data. And when we've done this, it's been after a long history of reviews that we've tried to resolve. And I think with both of those counties, it helped us resolve the issues that we saw. So here on page 4, what we would ask for Maverick and Zavala, and Maverick would do this after they submit a report response to us, and Zavala could do it as soon as we notify them, is on a monthly basis, they would provide to us the number of magistrate warnings for both felony and misdemeanor cases, the number of requests for counsel, and the number of appointments and denials of indigence. We have a motion. We do not believe that we need the full board to pass this motion. This is just a committee motion, and it's basically to give staff direction that this is indeed the direction we want to go, because we're not requiring all counties to supply this data, just these 2 counties. And so with that, I was wondering if we have further discussion or if we want to go forward with the motion.
I had a question.
Go ahead, Judge.
When Harris and Dallas counties were being monitored more frequently, we made it quarterly, and this is monthly. Was quarterly not really adequate?
Well, I mean, we could do quarterly. The reason we did quarterly there is we were tracking the distribution of appointments. We could do it quarterly. It's just that it kind of puts it on the radar. Hey, you need to report this right away. So I don't really have a huge preference between quarterly and monthly.
I don't have a problem with monthly. I just wondered why it was different, and I will move to require. Well, actually, I don't know what the motion is, but to require what your recommendation is.
So the way it's worded is the motion requires Zavala and Maverick counties to report the data listed on page 4, as Joel just read it, of the meeting book to TIDC on a monthly basis.
So move.
Okay, and I second. And is there anyone from Zavala and Maverick counties that wants to comment before we vote on it?
As near as I can tell, no one has actually joined the meeting from there.
Okay.
So it appears no.
Okay, well then I call for a vote. I vote aye.
Aye.
Okay.
Aye.
It passes. All right, so that's the end of that item. So we're up to legislative proposals. And I guess we're going in order, and Olivia, you're taking the first one?
I thought I might just give a quick.
Oh yeah, I'm sorry.
No worries, Mr. Butler. So we've since y'all last met, the work group that was appointed has met twice. So we had an in-person meeting June 10th and a Zoom meeting on July 29th. We had really good attendance. On page 12, you can see who was invited. We had, like I said, strong attendance. We had a couple of judges, county representatives, nonprofits, the whole shebang. We've also included the updated legislative policy beginning on page 14. We've removed the references to making recommendations to the federal government and Congress for action. So that's gone. And the one relevant point for today's meeting is actually on page 15. It says the Policies and Standards Committee shall include its recommendations to the commission legislative positions approved by a majority vote of the committee members present and voting. So I guess if we only have 2 members, that means we'll have to have unanimity from this group to move forward to the full. But your actions today are basically to recommend to the full board any proposals you'd like to see adopted. And those will be taken up, of course, at the August 19th meeting. So we can find it. And that was it. I just want to give a quick overview of where we're at.
I mean, I would assume, unless our other member joins us, if the judge and I disagree, it just goes on to the full board. Is that basically how we would do it? Okay.
That's
All
right.
right.
I mean,
I think it'd be up to y'all. It's not totally clear. I mean, the thing does say majority vote, so I don't know where we are if we have a one and one.
I'm just using as precedent. The last time we had a disagreement, we just sent it on the full board, and then I lost. So
I thought I lost.
no, I think you won one.
Okay, I'm going to lose one today. Then that's what it is. or at the next meeting. You know, I think because of all the work that's gone into this, it makes sense to present it even without, just with an explanation and then without a committee motion.
That sounds fine. Yeah, well, we can definitely do that, Judge.
Okay.
So now do you want to go forward with the individual ones still?
I think so. Yep, and you're right. Olivia's up.
Who is first?
Thanks, y'all. Hello, everyone. So proposal 1 starts on page 19 of the meeting book, and it was proposed by Ted Wood at the Harris County Public Defender Office. And it would amend Article 26.05 of the Code of Criminal Procedure in order to prohibit plea bargains requiring defendants to pay for their court-appointed attorneys without prior court approval. So in many counties, indigent defendants who plead guilty are required to pay for their court-appointed attorney. However, defendants should only be required to pay for this if there's been a judicial finding that the defendant can afford to pay. So this legislation would basically make that requirement more clear. This proposal has had 3 different versions over the course of the legislative work group this summer, and it has been approved in concept. This is the second time this proposal has been proposed, and it was not approved by the work group back in 2018. And this time around, people had some similar concerns as the last time, which would that this could limit the discretion of the parties and potentially prevent these pleas from happening. The second draft of the proposal worked on this summer and by a subgroup tried to address those concerns by making it 26.05G not waivable. And many people at the work group agreed that this was a good idea. And then we had more feedback on that from the second legislative work group. And this is the version that came out of that is in your meeting book. And the opposition to the 26.05G being not waivable was that it could potentially be an overreach and not letting a defendant waive if he or she wanted to. Some pointed out that this would be a problem of judicial failure if there was not a finding that the defendant could afford to pay. And there was also agreement that under existing law, the judges are required to already do this, but it doesn't seem to be happening right now, which is why this proposal has been brought. So the more specific language, the third version of the proposal in your book puts the onus back on the judge, saying the ability to pay would need to be found regardless of any agreement between the defendant and the state. And this was approved in concept at the meeting, and there was no further comment from the legislative work group since that meeting. And we have Ted Wood here, and we are also here if you have any questions on this proposal.
When it was approved, may I, Alex?
Yes.
When it was approved in concept, was there still any dissent or any opposition? When you say approved in concept, was that unanimous?
I believe so, yeah.
Well, go ahead, Olivia.
Yes, I believe so. And there were we said if there were any further comments and that we didn't get any responses or any further opposition, we didn't get any responses.
Thanks.
Any other discussion on that one? Okay, so unless you want to hear anything more, we'll take a vote.
Okay, I
All
vote no.
All right, I vote yes. So
Okay.
it just moves on to the next stage.
Okay.
With your comment, yes. All right, so number 2, that's Scott. You're mute.
Yes, got it. Hi, good afternoon. So proposal number 2 is actually a TID staff proposal. And basically it comes out of some observations that we have seen during our policy monitoring. And so in a couple of counties, we have seen judges taking pleas, and this is in misdemeanor courts, from unrepresented defendants without those defendants being advised first of their right to counsel and being given an opportunity to request counsel. This proposal started off with bigger changes to the waiver statute, 1.051 F1 and F2. We decided to scale that back and really just stick to the provisions regarding requiring a judicial advisal about the right to counsel at arraignment or the first appearance. And during our discussions during the second meeting, Jim Allison had suggested that we add, it used to just say before a plea was taken, and he suggested that we add before a guilty plea or no contest plea was taken. And so we added that language. We sent out the revised language to the committee and did not hear any other concerns regarding the proposal. And I think that's it. Oh, I guess I should also add, a lot of the language here is very similar to language in the magistration statute, Article 1517. It's also similar to some language I discovered reading some recent case law regarding parental representation, and that's at 107.103 of the Family Code. So a lot of that language in 26033A was taken from that Family Code provision, and basically a similar thing is done in those kinds of cases at the first appearance to advise defendants in parental representation cases about their right to be represented by an attorney and to have a court-appointed counsel appointed.
Alex, I'm not necessarily against this, but the last line on the issues raised is Jim will review the new proposal language further, and I'd like to hear from Jim before I decide whether to vote yes on it. So I'm a no at this point, but not necessarily going forward.
Judge, he was invited to this meeting. He did say he had an interim hearing this morning. He hoped will be finished by this point, but by his absence, I'm thinking it wasn't.
Yeah.
So we could invite him to join us at the full board meeting.
Okay.
I haven't heard any, I mean, I've had contact with him and actually asked him to provide any further feedback he might have had, and he didn't, but that doesn't mean he doesn't have a comment. So
Yeah.
Happy to make sure he's included at the meeting next week.
That would be great.
All right, well, I'm a yes, so we'll just move it on to the full board with those comments.
Okay.
Let's see. Number 3, we're back to Olivia.
Yeah. So proposal number 3 can be found on page 25 of your meeting book, and it was brought by Jim Bethke at the Bexar County MAC. And it would add language to section 411.082 of the government code to give managed assigned counsel programs free access to DPS's criminal history information. So back in 2013, SB 1044 gave the public defender offices and the Office of Capital and Forensic Writs free access to this criminal history information. And that particular proposal was vetted and approved by the TIDC Ledge Work Group, but it was not considered by the TIDC board at that time. So Harris County PDO had found its own sponsor and got that bill passed. There were no objections to this at either work group. There were some questions about implementation that seemed to be resolved at the work groups. And so there's consensus on this proposal, and Jim Bethke is here if you have any questions, and we're here as well.
I have a question for Scott because it was the same question. He had the same question I did. What does DPS think?
I don't know. There was not any inquiry made to DPS during our review. Frankly, some of the issues that I thought that they would have, Jim, I thought addressed them in terms of really I thought the one thing that DPS might have to say is, or have some questions about, is records retention, and how they have certain records retention requirements as part of their regulations. And Jim, I thought, did a good job in terms of laying out how they planned on retaining those records properly. But a conversation has not been had with DPS thus far.
Well, here's why I ask, because I don't have a problem with this at all, but it strikes me that there's a difference between PD's offices getting the information and Max getting the information. My first question is, why can't private counsel get it free too? If it's available to the Max, essentially it's available to private counsel, right? So why is somebody with his own office not able to get it free too? And is it because someone at the office has to take responsibility for making sure that the information is not misused? And I'm guessing that Alex does that for the Harris County PD's
We're in
office.
the middle of our audit right now. I think this is our second audit since we've started. So it is a little bit cumbersome that they have to come and make sure you're doing all these various security measures. And if it's paper, it's got to be in a locked cabinet. And if it's electronic, there's got to be all kinds of other protections. So it's a little bit onerous. And so what I envision Jim was talking about, and he can correct me, is that the MAC as an administrative office is the holder and not just all these different lawyers. They would, I mean, these offices typically have an investigator that's the head investigator. That person could be the one that holds on to this information. And it's really the reports themselves that they want to keep secret, not, I mean, the information is public. It's, if you paid the money, any citizen could get this. So I think it's more about keeping the record safe. And I'm pretty confident that a MAC could do that.
Well, I don't have a problem with this. Jim, did you have anything? I mean, I'm going to vote yes, but if you have something to add, please.
Hello, everyone. No, I think the conversation was good, and we will have a standard operating procedure on it. And I concur with Alex. I think I would have no objection to the private bar having access to it, but each individual attorney is probably not going to want to have that level of scrutiny and be subject to audit. So this is kind of a tiny step forward.
Okay. Well, Alex, I vote yes.
I vote yes. We're unanimous.
Okay.
First one. Let's see. Okay, Scott, number 4.
Yes, so proposal number 4 is a modification of a proposal that the TIDC board approved last legislative session. It clarifies the duties of managed assigned counsel programs. It clearly authorizes MACs to have oversight boards and authorizes MACs to appoint counsel in death penalty cases if the judges in a county authorize the MAC to do so. As I mentioned, this was some of this was approved previously by the TIDC board and was introduced in HB 2608 last session. The provisions here were vetted by directors of the MAC programs in Texas. There's just to clear up any confusion you might have regarding the different text colors. Black text is provisions that were in the previous proposal that the board approved. Red text is existing law, but not part of the previous MAC proposal. And red underlined text is proposed changes in the law that were not included in last session's proposal. So section 1 on page 28, this gives clear statutory authority for the MAC to remove counsel from representing a defendant or removing a counsel from an appointment list. Good cause would be required to remove counsel from representing a defendant. Section 2 on page 28 and 29 clarifies that MACs do things like approve payments for lawyers, investigators, and experts, and oversee and improve the quality of representation. It also establishes that information received by the MAC is subject to attorney-client privilege, and attorney work product privilege is protected from disclosure, and the MAC must maintain confidentiality of material it receives as part of its duties. Some of those issues have come up during LPDO and oversight of Operation Lone Star cases. Section 3 would require the MAC plan of operation to have a written policy describing when an attorney may withdraw from a case and when good cause is established to remove an attorney from a case. Section 3, page 30 to 31, authorizes MACs to have oversight boards, and that was previously approved by TIDC's board. Section 4, page 31, clarifies that MAC directors can have a designee approved payment, and it doesn't just have to be the MAC director. Obviously, in counties that are very large, practically impossible for a MAC director to approve all payments to attorneys. And in section 5, page 32, that authorizes MACs to appoint counsel in capital cases. That was previously approved by TIDC's board. The only issue raised during our work group discussions was Jim Allison raised a concern about language that was previously in section 5 that would have required a county with a MAC program to fund all capital felony expenses that were approved by the MAC director. And so we thought it best just to remove that provision. So the capital defense provisions here for MAC is exactly as previously approved by TIDC's board. We have a few guests here. Bradley Hargis is the director of the MAC here in Travis County. Jim Beskey, obviously, with the Bexar County MAC. So if y'all had any questions regarding some of these provisions, I think the two of them as MAC directors could be in a better position than me to address them.
I have a couple of questions.
Go ahead, Judge.
Okay, the first thing is, do we care in these, like on page 28, about grammatical correctness? If I see some things that could take a couple of grammatical corrections, is this the time to do it?
It's as
Or
good as
is
any.
this just, okay.
Not spelling stuff wrong again?
No, it's just a little ambiguity on page 28. Under revised proposal, second, third, fourth, fifth, sixth line down. I think it should say, or remove counsel from representing a defendant or from an appointment list. That's all on that page.
Or from an appointment list?
Add a from between or and appointment list.
Okay.
On the next page, second line, there should be an or between investigator and expert. And then on about the 10th line down, the line that starts the constitutional or statutory rights, it should say of clients, no comma, who are represented, instead of the client, comma, who are represented. Very minor.
Of clients who are represented?
Clients who are and no comma.
Got it. Okay.
Okay, then all the way to page 32. And this is a substantive question. If MACs have the authority to appoint attorneys in capital cases, what happens in counties that have a MAC but are also members of RPDO? Like Lubbock, for instance.
Well, B2, I think, is attempting to address that issue where it talks about if a county is served by a public defender's office and a MAC, the presiding judge of the district court in which the case is filed shall give priority in appointing counsel from the public defender's office. So RPDO would get the appointment first. They are the priority in the case, and if then they could not represent somebody, then the MAC would appoint somebody off of their capital list.
Do you think there might be counties who drop out of the RPDO if they have max that'll take capital cases?
I don't think so. Yeah, because I think because TIDC is helping support so much of the RPDO, I think counties see it as a much better deal. But I think also the overlap isn't that big in that RPDO really is serving the rural and mid-sized counties, and most of the max are really in the urban areas. I think Lubbock is one of the smallest that we've got.
Is Lubbock the only one with an overlap?
It's the only one I can think of. Scott, can you think of any? Because Bear County, Harris, Travis are all too
Those
big.
are too big. Yeah.
Yeah.
Well, I don't want to get us in a position where people think I don't want to pay the dues for the RPDO because I can get the MAC appointed anyway. But if y'all don't think that's a problem, then I will let it go. I think that's the only question I had about that. And why is it that we want the max? Because why do we want the max to be able to do that?
Well, I think the MAC brings some of the advantages in capital cases like it brings in other types of cases. There would be, I think, additional oversight over the attorneys who are providing private attorneys or representing capital defendants. They'd be able to go to the MAC to request an investigator, stuff like that.
Okay, that's fine. Thanks.
Sure.
Those are my only questions, Alex.
Okay, so with those changes,
I'm
then
yes.
you vote yes. Okay, then I'm yes too. And if I don't have a lot of comments, because I've already sat through 2 long meetings about this, so.
Okay.
So we're good on that, and we just have one more. Wesley, you're doing that one.
That's right. One more new proposal, at least. That's number 5. And this would allow counties to be reimbursed for representation provided by the local public defender's office when that office is appointed to represent an indigent inmate when the state counsel for offenders cannot do so. And so the main thing is statute currently provides that if the state counsel for offenders can't provide representation, often it's due to a conflict of interest, the judge appoints local attorney, private attorneys. At the time the statute was written, there really weren't many public defender offices. And so what's happened is in South Texas and the Beeville office, B County, there is a prison, and the court there has been appointing the public defender office, which is operated in that county by TRALA. And at the moment, they aren't getting any reimbursement from the state for that representation. And it's about 30 or 40 cases a year is what the estimate is. And that's just because the statute doesn't clearly provide a way or a method for reimbursement when it's a public defender who's appointed. So there was consensus and really unanimity on the work group that this was good policy. It should go into effect. And this would allow the PDO, public defender, to certify to the court the amount of expenses incurred in the representation of the inmate, and thereby let the court submit on behalf of the county to the controller for reimbursement.
And before we go any further, just want the record to reflect Chair Collier's here now. And just to fill you in, Chair, with the previous legislative proposals will all go to the full board, even though a couple of them Judge Keller and I split on, but they're all going to go. So you did not, you're not being there did not change those outcomes. But as to this one, Judge Keller, Chair Keller, do you have comments about what Wesley laid out?
I had a question.
Go ahead.
Is this not a problem for MACs as well? Are there no MACs that are having the same issue?
I haven't heard of any MACs having this issue. I'm not sure there's any prisons in MAC counties yet, but because those are still private attorneys, I think, and they would be paid a fee for their representation, I think they'd be covered already by the statute as it is now, because it's the same assigned counsel scenario that the statute envisions.
That was my only question. I'm in favor of this.
I am too. Okay. So you're for that, Chair Collier? Okay. So that's unanimous, 3 votes.
Okay.
All right. So now we have the old legislative proposals that did not get through last time, but were approved by everyone before. So you want to lay those out, Wesley, just real quick?
Yeah, I mean, since it was the same three of y'all on the committee last time, my thought is I'll just read the headline, and if you want to talk more about it, I can go into more details. But as you pointed, these were all approved previously. There's no known opposition. They just haven't made it through the legislative process to this point. As you know, many proposals take a while. So number 6 would be to repeal the requirement that public defender attorneys must inform the court of the results of any investigation into a defendant's financial circumstances. It could violate attorney-client privilege, and this came from the Harris County Public Defender's Office. Number 7 the next two really deal with representation at magistration proceedings, and this would specifically provide for the limited scope representation just for a 1517 proceeding. Statute right now could be read to say that the attorney once appointed, needs to stay on the case until it's disposed. Number 8 would allow attorneys who are in private criminal practice, have a private criminal practice, to work part-time in a public defender office just to represent arrestees at magistration proceedings. Right now, that's not permitted, and there are offices, Fort Bend Public Defender, for instance, who actually have hired civil attorneys to provide this representation because of this prohibition in the statute. Number 9, this comes from the Dallas County DA's office. Actually, they asked for our support last session and have again this session to require a court to appoint an attorney to represent an indigent defendant to investigate and file a writ of habeas corpus when there may be a meritorious claim of relief from the prior conviction that needs investigation by an attorney. And of course, the DA in those cases can't advise or investigate on behalf of the defendant. Although their conviction integrity units may in fact uncover potential wrongful convictions, and that's where they've asked for this exception to the normal rule that you aren't entitled to representation in a writ. So
Wesley, let me ask you a question if I may. Okay, Alex?
Yep.
I remember when this came up before, asking whether the judges were failing to appoint counsel when the state suggested that there might be merit to an writ application. I don't remember there being a problem. I'm not against this, but I'm just not sure it's necessary.
They did represent us that there were certain courts in Dallas County where they did not appoint, and where the DA had suggested that the court should appoint. So I think it actually is a problem, but I think it's very limited. I mean, for one thing, the circumstances under which this sort of representation would arise are very limited, but there were cases that I've heard of.
Okay, that's all. You may continue. I had nothing else about that one.
Okay, and then number 10, moving down a page or two, this is really to clarify and rewrite, if you will, Article 1517 to make it much easier to read, really breaking out into paragraphs and sections, rather into sections from paragraphs, the text of what's required to be done. The only real substantive change is to establish a requirement for magistration records to be preserved for at least 3 years. Right now, the statute could be read that they only need to be held for 90 or 120 days, depending upon whether it's a misdemeanor or a felony. So that's the only substantive change. Once again, there was no opposition that we know of. Proposal 11 is to ensure lawyer visitation with defendants who are held in out-of-county jails pre-trial. So there's almost 2,000 inmates at last count who are held in out-of-county facilities, and defense attorneys have a really tough time visiting them, especially if they're paid on a flat fee basis to take the time to drive potentially significant distances. So this would just require that be included in the fee schedules of counties where they're holding pretrial inmates out of county, that if it's more than 50 miles away, that they have some provision to pay for that travel to have that attorney-client meeting.
I had some comments about this one.
Okay.
May I, Alex?
Yes.
Okay, the first thing is the title. When it said ensure lawyer visitation to defendants held in out-of-county jails, I thought, are the jailers not letting people visit? So I don't think that the caption or the backgrounded purpose is as precise as it could be because it's about paying lawyers.
So it's your travel, maybe.
Right. So I'm guessing that if they travel, they're not having trouble visiting their clients, right?
That's
That we
right.
know of.
Right.
I also wonder, don't we or haven't we paid for video or remote systems so that lawyers can visit their clients in jails where they're not nearby? Have we?
Not sure if we paid for it, but I mean, it does exist in many places. And I think a lot of the attorney-client contacts may be happening in that way, but it probably depends on the jurisdiction and what facilities the jail has.
Okay, well, I may be wrong, but I think we have paid for video systems that promote the ability of lawyers to talk to their clients privately.
You're correct.
Regardless of
one
what
system.
happens to this bill, is that something that we should make sure that counties have? That's one question. And that's aside from what we're voting on today. And the other thing is on D3B, any costs associated with remotely conducting a confidential interview. What would those costs be? I mean, I don't think that the county ought to be paying for, the state ought to be paying for like a lawyer's internet service or something like that. So I don't know what that refers to.
We didn't really talk about that clause specifically. I mean, it could be the attorney's time, right? Their actual time to get there and meet with a client in a remote facility.
Well, we ought to pay for that for sure, but I think any cost associated might be misinterpreted because, I mean, if you and I can't think of what they are right now, then maybe we don't need any cost associated with remotely conducting an interview. I don't know.
I mean, I think we do need to have something to clearly say that the attorney time or fees for the attorney's time, because that's really the issue is attorneys in jurisdictions where they're paid a flat fee, they're finding in some cases, that's what brought this proposal to the fore and why Nate brought it to the
time and mileage.
Time and mileage, I think is right.
Yeah. What did you just say, Wesley?
Well, the reason it got brought forward is I think the attorneys weren't being paid for their time to go visit their clients in jurisdictions that have flat fee schedules. So perhaps you're going to be paid $250 for a misdemeanor, and the courts weren't authorizing anything beyond that, even if you had to drive 100 miles to go visit your clients. So a lot of times attorneys weren't visiting their clients.
But the any costs is associated with remote interview.
Oh, that's true.
Yeah.
Well, the fees may need to be more clearly written here.
Well, I agree with this in concept, but I'm not sure it's saying exactly what we need to say, because we want lawyers paid for their travel time and expenses. If they're getting a flat fee for representation, then they shouldn't get extra money for meeting with the client remotely, right?
I wouldn't think. Yeah.
Well, it sounds from this like I don't know what it sounds like, but that's my concern with this one.
Did we work on this in the interim before the board meeting next week and clarify this provision?
Get some language from somewhere else to make it clear.
And let me ask one more thing, because I think Alex can answer this, but I was thinking maybe we should prioritize remote interviews, but if you think it should be up to the defense attorney, I don't want to do that. But otherwise, I would say
I would not, because
what do you think?
So there are many interviews that can be done remotely.
Okay.
But there's always going to be some, for many reasons, that you need to be there.
Okay.
When an important decision is made, it should be face to face. And also, a lot of lawyers are not trusting some of these services. The most famous is Securus. They're known for having released data to law enforcement. So, we would like lawyers to use the remote services to eliminate things like telling clients when they're going to meet with them next time, just getting them their next court date, things that are all almost public anyway. but you don't want to hamstring them from not being able to have confidential meetings. So
That's kind of what I thought you would say. That's fine. Chair Collier?
Oh, yes, thank you, Your Honor. I do support the idea of virtual or remote meetings, but I'm very concerned about the reliability of broadband technology in a lot of these rural communities. We still don't have, strong connectivity. So to, put a lot of reliance on that, but I heard you, walking back saying maybe we don't prioritize it, but we give it as an option. And if they're paid a flat fee, I agree that you wouldn't get, any additional money if that was the agreement. But maybe we need to look at something like that. I don't know how much, they're getting paid. But if you're saying that the purpose of this number 11 is to ensure reimbursement or payment for virtual meetings, then yes, I would support that. But not if they already agreed to a flat fee.
Okay, well, I think Wesley's right that, or Alex is right, that if with just a little bit of working on the language, this should be fine. So I'm going to go ahead and vote for it as is. Be prepared to talk about it if I'm not happy with the language at the big meeting. How about that?
that's
That sounds great. And I had suggested that this slate of the number 6 through number 12 be voted on together since they've been previously approved, if that's okay, and we can work on this one and pull it out and review it separately, Judge, at the next meeting.
Well, this language hasn't been voted on before, has it?
Yes, I believe it has.
Oh,
yeah.
All of these proposals were previously adopted by the board. Yeah.
We can revisit that one.
Yeah, we
Okay.
can. And we haven't talked about it in 2 years, so it's not top of mind for me either.
Well, honestly, I had trouble figuring out what the red line was, what the red text was, what the underline was, so I probably just lost track.
Yeah.
Okay.
And Mr. Bunnan, you might have add a quick comment before we
Yes.
move on. Judge, your recollection's right. We have funded projects to help attorneys communicate with their clients in jail before. And in fact, I think the most recent one, we did something in Far West Texas a couple of years ago. Couple different issues that have come up, and I think this is aside from the bill. I mean, this is something I think the board can talk about later. One is that a lot of times the obstacle isn't so much the technology as it is having the space and the staff to help run it. That's what we've heard again and again from jails. The second issue that's come up with the board, and when the board has talked about it before, is at what point do we draw the line and say, hey, this is something that jails need to fund. This isn't really indigent defense, and that's always been a little bit of a debate. But again, I don't think any of that affects the bill directly, but it's a good point.
Okay, thanks.
So do we need to revisit any of the others, or can we just vote to send this to the board? Yes, Chair.
What happened to number 7?
What happened to it? Let's see.
Sure, Colin, we haven't actually voted on any of these.
Yeah, we
so-
haven't.
Yeah.
Nothing's happened.
It's
So
fine,
if
yeah.
you want to comment on it, Chair, go ahead.
I like that one. It says provide for a limited scope attorney appointment to represent an arrestee at an Article 1517 hearing at magistration. I'm sorry, I missed that last meeting, so I didn't get a chance to discuss this with you, but I do support this concept and this
Good.
provision.
Yeah, it was it was part of our legislative package last time. It just never got out of Senate criminal justice. So,
Okay, all right, so this one is going to go to full board?
yeah.
Okay.
So can we agree, other than those possible tweaks to the distant visitation bill, that these can all be submitted to the full board?
I agree.
I
Okay,
agree.
and that's unanimous.
You're talking about 6 through 12.
Right. I didn't cover 12, but if y'all have read it and are good with it, we can, yeah, I'm
good with it.
So, great.
Okay, so that's the end of legislation. Now we're going to do a report on standards for determining indigence. And that's Kristen.
Yes, hello. Good afternoon, everyone. So this is just kind of a brief update on kind of our indigent standards research that we've been doing. And so we're not actually covering any actual proposals today. Those will be presented to y'all at a future meeting. Just as a reminder for kind of how we got here, at our last policy and standards meeting, the Deason Center's Professor Pamela Metzger and Dr. Andrew Davies presented on Texas indigent standards based on their most recent publication called Getting Gideon Right. And as a result of that presentation, the committee asked the staff from the policy team to kind of look into indigent standards a bit more. As a result, we've done some work on that. We've reviewed some standards that are both across the nation in different states, as well as we looked at some means-tested indigence or poverty measures for the state of Texas for public benefits. And so I'm just going to kind of walk through a little bit of the findings that we've done, the research, and then we plan to propose several options at the next meeting. So this starts on page 50 in your meeting book. I realize I did not say that, so go all the way to 50. And I'm going to start with the national standards. So we reviewed indigent standards for the other 49 different states and found kind of various methods of determining indigence. There was generally the kind of two different buckets. There were these presumptions of indigence, which are where you say, okay, if you meet XYZ criteria, then you are considered indigent. And there's a presumption of that versus additional other standards where you're taking a bit more measurements or a closer look at a person's individual kind of standing. The common presumptions we found were a percentage of the federal poverty guidelines, which is something we're very familiar with here in Texas, as a lot of our counties use that. Whether or not someone is receiving public benefits. And then another one that was presumption is whether or not a person resides in a correctional or public mental health institution. Some of the other standards that we saw around the country included different tiers of net income or assets based on the level of criminal charge. So in those cases, it would say if you have a net income of a certain level and you are facing a misdemeanor charge, if you are under that level, then you would be eligible to qualify as indigent, and it would break it out based on the level of charge in many cases, which makes sense because oftentimes representation for a misdemeanor versus a felony is quite a bit different in how much that cost or the time or scope of that representation can vary. And then also we saw that some states considered an estimated cost of representation when making these indigence determinations. And oftentimes those estimated costs were based on the level of charge a person was facing. That was kind of a little summary of our national standards that we saw from across the country in criminal defense indigency. We also found that there were kind of 3 different calculation models for poverty measures. The one that we're all very familiar with is the federal poverty guidelines. It's the official poverty measure of the United States, and it's based on primarily a single cost, which is the cost of food, and that's how that is determined. It does not consider the local cost of living and the various kind of communities that live across the state or the country. So it does not change depending on where you live, and it doesn't change depending on how much other kind of cost adjusts because it's based on a single item calculation. 22 different states use a percentage of these guidelines and their presumptive eligibility. And the distribution, there's a chart in the meeting book that you can see kind of where the different states fall. You'll notice that they fall kind of across the spectrum, everywhere from 100% all the way up to 200% of those federal poverty guidelines. And keep that chart in mind because when I go back to the Texas ones, you'll see a distribution for the district, the county, and the juvenile boards as well. And you'll see where our distribution falls in relative respect to that one. It can be a good comparison. The second kind of method for calculation that we found that was available is called the living wage calculator. And the idea of the living wage calculator is it determines your minimum income level for a household to meet this basic minimum subsistence, making all of the necessary purchases, which are food, housing, childcare, transportation, and it's based on a market approach. So instead of it being a single item kind of cost measure, it's saying kind of what does it cost for these various necessities, but not just that. It says, what does it cost for these necessities on your geographic location? So it's a localized determination of how much it costs for you to live and survive in a specific area. down to the county level to metro areas. This is used in various places. I know the Dallas City Council has used it for various, looking at changing income or salaries. Other corporations and such have also used it. I know Tarrant County's district court lists it in their ID plan and uses the living wage calculator for their presumption of indigency. And that's the living wage standard. The third kind of calculation we saw, and this one will sound very similar to the living wage calculator, is called the self-sufficiency standard. Now, what it does is it also is looking to provide a minimally adequate level of subsistence living based on the geographic location. The difference here is that it actually breaks it down one step farther to a family type approach, which means it's based on a large amount of necessities. What do you need? What's the bare minimum you can do with? But it also considers what the age and the number of your dependents are, your children. So it breaks that out by, do you have an infant? Infants are pretty expensive. What is your preschooler? How much is that costing you? Do you have a school-age child? Do you have a teenager? And so it kind of puts together the number of adults and children and breaks that out also on a geographic level. So it says, how much does it cost for you based on your family type in a specific area to make ends meet at a bare minimum level? Now, this is also used in a few places as well. One example of that would be Virginia's Temporary Assistance for Needy Families Authorization Committee, uses their standard to set eligibility requirements. But that's the third one, is self-sufficiency standard. And they all vary a little bit in how many actual dollars people are putting out there as this is a level of poverty measure or this is a level of indigence. But those are the three kind of big calculators that we found across the nation. Taking a step back on the national standards, looking at civil legal aid. For comparison, the Legal Services Corporation is the largest funder of civil legal aid in the country, and they require that income be equal or less than 125% of those federal poverty guidelines. On the other hand, the Taxpayer Advocate Service, which is free representation for kind of your tax issues, says that households up to 250% of the federal poverty guidelines can receive assistance in legal aid funding. Those are kind of the national lens scope that we looked at. And then we're going to move on to the Texas standards. I know that as part of their presentation on getting Gideon right, the Eaton Center dove into these quite a bit. So I'm not going to linger too much on the criminal standards, but I did want to point out a couple of things. So in the Texas indigent standards for criminal cases, you'll notice that I have a couple charts here. One is about the number of counties that use the federal poverty guidelines in some form. Now, while they may use different percentages, only 14 district or county courts and then only 16 juvenile boards do not use them as part of their indigent standards determination. You can see the charts listed below there, beginning on that third page of this section. And just as a note here, you'll notice that a lot of the counties are using 125% of the federal poverty guidelines. 125% of the federal poverty guidelines for a family of two is just under $23,000. And as a reminder, this does not include what your local cost of living is, doesn't consider necessary expenses, nor does it consider family composition, just to delineate it from the living wage calculator standard we talked about and the self-sufficiency standard. One other thing that we've seen, a couple other things we've seen in Texas that are pretty common are the difference between income and expenses, as well as having a allowable eligible range for those expenses. So the difference between income and expenses varied from just $200 over of the difference, and that would in theory be enough to help cover your cost, all the way up to $2,500 to be able to cover the cost of representation. There's a couple more presumptions that exist in Texas that we've seen in different counties. One is whether a person resides in an institution. So that would be if it's a correctional institution or a public mental health institution. And actually only 36 counties or district courts don't make that presumption, and that being 35 that in juvenile boards that don't presume if you reside in an institution, you are not presumptively indigent. And then the last kind of presumption that we've seen a lot across Texas is the public benefits presumption. So if you qualify or if you're receiving public benefits, you are presumptively considered to be indigent. Only 21 counties in district or county courts do not presume a person is indigent when they receive certain public benefits. And for juvenile boards, it's 24 counties that do not. Moving back to civil legal aid in Texas, you'll notice that the standard tends to sit around that same 125% of the federal poverty guidelines. This is usually in part because some of the local organizations receive funding from the Legal Services Corporation, which is the national one, and their set is at 125%. But you'll notice that some of them allow some wiggle room. 125% may be kind of their initial threshold, but they often will allow people with incomes up to 200% or more than 125% will be allowed to qualify for civil legal aid if there are certain expenses, economic factors, or some sort of special issue at stake there. The last thing I wanted to point you to in the meeting book on the last page of this section is we looked at Texas mean tested public benefits. So the public benefits that Texas already provides funding for and support for, how do you become eligible for those? And what are the criteria? So we reviewed program eligibility standards for various programs, some of which are very familiar, some are less familiar before we did the research. So things like TexCare's Children's Health Insurance Program, so CHIP, things like Supplemental Nutrition Assistance Programs, and on and on. Things that we found in the eligibility requirements there, they varied, of course, but one thing we noticed is that the actual income standards were higher than most counties' criminal indigence standards that exist across the board. Now, the income limits for these programs were generally well above 100% of federal poverty guidelines, and most were over 125%, which you'll notice was the most commonly used standard for district, county, and juvenile courts when looking at the counties here in Texas. Most of the income limits for these programs ranged from 150 to over 200% of the federal poverty guidelines. That's kind of the overview of what we've looked at. And I think this kind of informs us about what informs us and informs you what exists in the world as it sits. And so we are looking forward to potentially exploring other policy options and bringing proposals to y'all at the next meeting. I will return the floor back to y'all, and I'm happy to answer any questions.
Thank you. Thank you. Are there questions for Kristen?
I have a question.
Yes, Judge.
This is great information. And I mean, we heard that great presentation at the last meeting, and I really appreciate y'all. I don't know who worked with you on this, but I really appreciate the work that you put into it because it's a lot of really good information. It makes me kind of wonder what the federal poverty guidelines are based on. Do you know?
Yes, ma'am. So actually the way that the federal poverty guidelines were originally developed is they're originally developed based on a kind of emergency measures food budget. And it was based on a couple of things. One, it was this very bare bones menu where be able to feed your family in an emergency basis only, kind of very big, not even barely substantial measure. And the reason why it came about is because they were looking to see, how do we measure poverty? How do we measure this thing that has a lot of different factors? So they said, well, we know that food in that time was about a third of a household's expenses. That was how much people spent on food. Usually it was a third of their income. So they said, okay, what is this bare bones minimum that you need to survive? And it costs a third of your income to buy food. Great. If you multiply that times 3, then you have kind of your medium existence cost for living. And that's generally how it was kind of put together. It is adjusted based on the consumer price index regularly, and that's kind of how the adjustment is made. But that's one of the differences, is it's based on a kind of a single basket. It's not really a basket, it has one item in it, but that's how it came about.
Thank you. Thank you very much. So it's helpful, but it's not very nuanced. Right. What was I going to ask? Oh, at the presentation at the last meeting, the presenters focused on the counties that were not doing as well as they should, but most of the counties by far were not having problems. And I think, tell me, y'all can remind me if I'm wrong, but I think there were over 150 of the counties, maybe even quite a bit more than that, that the Decent Center did not really think were inadequately funding indigent defense. So one of my questions is, now this is actually the big question. When you're talking about making recommendations to at the next Policies and Standards Committee, to consider at the next December meeting, I don't want us to jump over the question of whether we want to institute a statewide standard for indigent determination. Because if most of the counties are doing it fine, I think there has to be a case made for why we would take that discretion away from the counties and impose a statewide standard. Not that that's a bad thing, but I think that before we make everybody change, there ought to be a very good reason to do so. So when you say exploring potential policy options, are you thinking policy options for the state as a whole? Are you thinking policy options to offer to the counties to say this works really well? Or had y'all thought that far?
Yeah, Kristen, do you want to take that or do you want me to jump in?
You can go ahead and take that one and I'll add comments.
Yeah, I mean, I'm going to talk maybe, Judge, about the first part of your question and then maybe the second. I mean, the first part of the question, what's the problem we're trying to solve? And there are a few different problems. I think that the standard oftentimes isn't as we know, a lot of people who aren't getting attorneys, but oftentimes the standard isn't the problem there. A lot of times the standard exists, but it often isn't being applied in the correct way, and that's the problem that we see. So that's one problem. A different problem is when you have a standard that's maybe a little trickier to apply, and there isn't an easy tool, and that's one of the things we've kicked around on the staff side is, we worked on automation. Actually, Kristen has worked on automation, as you may remember from far west Texas and Concho Valley and all that. So that's yet another problem, right? Is how do we make this easier for magistrates and judges? And then maybe a last problem is, in some instances, I think as SMU pointed out, it is a little bit kind of funky when you have two counties right next door to each other, and one of them has 100% and another one has 200%, and you land on one side or the other. Sometimes that's a problem, but for the most part, that's not, I don't think, the biggest problem. To your second question, I think what we're talking about is a bunch of different options for the board. One would be, can we just do something to pilot a few different projects in a few different counties? So something that might combine the automation that Kristen's working on, along with maybe a living wage calculator or 125% of the poverty guidelines. That would be one option, perhaps. Another would be, we can go for a straight across the board standard for the state, but what might that be? So I think we're still trying to figure that out, but we want to come to you all with more than just, here's a standard for the state.
That's great, because there are a lot of options and it sounds like you've thought through them pretty well. And the idea of making it easier for counties to adopt a certain procedure, we've done that many times, right, where we just say, here's your template. You don't have to use it, but take it if you want or whatever. So I'm looking forward to seeing what y'all come up with, and I really appreciate the work.
It was Kristen and Olivia and Bill are the ones leading that. And they did a really, really good research on this. It's pretty cool.
Yeah, I agree. I think there can be variations, but there should be this way that these are being vetted, and we can tell counties these are some approved ways that we think are good ways of doing it, and they can make that choice. But we didn't have all this information before, and what Kristen's done and everybody else has done is really, really helpful for that. Did you have a comment, Chair?
Yes, thank you so much. Agree. Thank you so much for this information. It's very helpful. I really like that living wage calculator because it does offer flexibility, because the county, the local government would be able to determine the minimum income level. So I think that gives them, helps them retain some of the control or oversight over this. But, the limited time that I've been in front of criminal courts or visited some, a lot of them, the judges, they say, well, what about this? I wanted this to be included, and this would take out the guesswork. You would say all of that, may or may not be. You can, just say, like, they'll say, oh, they have a car that's worth this amount of money. And instead of just saying, your income is flat, this number, you could take into consideration the cost to live in that community, because living in Fort Worth is different than living in Austin. And different than living in Houston or even Dallas, which is, 30 miles away. So I think that, a hybrid or something like that, I really like that concept. making a recommendation. And Jeff, you made the case very clear, logical and reasonable as to why, this board would make some type of recommendation for change that would be uniform and consistent across the entire state, that still allows the local government to retain some autonomy and flexibility, because they would be determining their own minimum income level to, live in that community. So I really appreciate it. I will tell you when I first heard about the self-sufficiency standard, I didn't like it. I'm not fond of it. I don't, that gives more information than probably I'd want a judge to know about my personal financial situation. So I'm not too fond of that, just throwing that out there.
Thank you. Okay, so there's no motion, there's no action. We're going to hear more about this in the next meeting and later on. So the only thing left is, and I don't see any members of the public, but is there public comment? Hearing none. Do we have to schedule anything else, or are we ready to adjourn?
I think we're ready to adjourn, but just for your information, our plan is to schedule a P&S meeting, policies and standards meeting, prior to the next full board meeting, which hasn't yet been scheduled. So I think we'll schedule that one first and then set this one back at least a week or 2 weeks prior. And we'll Megan will reach out, or I will, through a doodle poll to find a time convenient.
Okay. Well, unless there's any objection, we are adjourned.
Thank you, Alex.
Thank you, Judge. Thank you.
Bye.
Oh, good to see you.